9 a.m. Bond continued with its conditions. Thank you. Court calls case of the people versus David. Is it Machasik? Machasik?
Good afternoon, Your Honor. Allie Zenda on behalf of the people.
Assistant Public Defender Melissa Kleeman on behalf of Mr. Machasik. And sir, can you unmute and state your name for the record, please?
He took it off, stupid.
Okay, look, I don't know who you are, Life 3, but you're about to be kicked out of the courtroom.
Right out of the gate, this courtroom is already spiraling into chaos, and Judge Simpson is not playing around for even a second. You can instantly tell this is one of those hearings where the judge expected a routine docket call and instead walked into a digital circus. Somebody blurts out an insult while apparently forgetting they are in a live courtroom session, and the mood changes immediately. What makes this moment so wild is how fast Judge Simpson establishes control. No hesitation, no long lecture, just immediate courtroom authority. 5. And honestly, this is the kind of thing people underestimate about virtual hearings. Defendants and spectators sometimes start treating it like a group FaceTime call instead of an actual legal proceeding. But judges notice everything. Tone, attitude, interruptions, disrespect, it all matters. The second someone loses composure in court, it changes how everyone in the room views the situation. What also stands out here is that Judge Simpson still gives the person a chance to correct the issue instead of instantly exploding. That balance is important. Firm authority mixed with controlled professionalism. 5. But you can already feel the tension building because this hearing is clearly heading toward unpredictable territory. And trust me, when a judge has to start warning people before the actual case discussion even begins, that's usually a sign the rest of the hearing is not going to stay calm for long.
Mr. Machasik, can you figure that out? If you can't figure it out, there should be a clerk right near you somewhere. You can ask them for help to unmute.
I apologize, Judge Simpson.
Who are you?
Nathan Mason.
Got her. Okay, I don't want to ever hear that in my courtroom about anybody.
I apologize.
I don't know if that's going to be good enough, but I'll get you when you get to your case. Mute yourself.
Yes, Your Honor. This is John David.
Court calls the case of the people versus Nathan Mason. That's the one, right?
Good afternoon, Your Honor. Allie Zenda on behalf of the people.
Ready again, Judge. Torshell Feaster, Assistant Public Defender on behalf of Miss Mason. Miss Mason, please unmute and state your name for the record. Miss Mason, please unmute and state your name for the record.
Had a whole lot to say before.
Miss Mason, we're ready for court now. Would you please unmute and state your name for the record?
I already got in trouble because I thought I was muted and I wasn't. And this guy, he was calling this guy name. He was sitting there looking crazy. So I was like, he's looking off.
Miss Mason, we got
but I didn't know harm.
Miss Mason, will you state your name? State your name for the record, please.
Nathan Mason.
Thank you, Judge. Today's the date and time set for pretrial in this matter. I've spoken to Miss Mason and to the prosecutor's office.
How'd that go?
Now the courtroom is finally attempting to transition into actual legal business. But you can already sense that Miss Mason is struggling to stay focused on procedure, and this happens more often than people realize. Defendants walk into court carrying stress from multiple cases: fines, warrants, payment plans, transportation issues, probation obligations. Everything starts blending together in real time. The defense attorney is trying to keep this hearing narrow and controlled because this is only a pre-trial discussion. That matters. Judges cannot magically solve unrelated financial issues or prior court obligations just because a defendant wants clarification in the moment. Courtrooms operate case by case, file by file. But from Miss Mason's perspective, everything feels connected because it's all part of her personal legal mess. And this is where courtroom hearings become fascinating to watch. You can literally see the collision between legal structure and human frustration. One side is focused on procedure. The other side is focused on survival and confusion. Also, did you notice how quickly the judge and attorneys had to regain control after the earlier interruption? That tells you experienced courtroom professionals know momentum matters. Once hearings become emotionally loose, it becomes harder to keep defendants from talking themselves into worse situations.
No, go ahead.
It's been rough, Judge. At this time, there are no offers on this file. If we could adjourn this matter, Your Honor, so we can hopefully get an offer, and if not, move it forward in another way to resolve it, Judge.
But could I talk just? May I say something?
No. What do you not?
I was ordered to pay $180, but I don't have an income because I'm disabled now. So I was trying to explain to him that I talked to a court clerk at 14A District Court. I called the bus back up there and talked to her and told her my situation. She said I could make a payment plan, but they never sent me through the mail.
Miss Mason, is that this file? Because if that's not this case,
excuse me,
is that on this file? Because if it's not on this case, Judge Simpson cannot do anything about that today.
Well, which case is this? It got to be the one I went to. It got to be the one that I already got ruled on because is it a case from that I had a bench warrant on? It was a warrant out for me on this case because I did pay the $180.
Okay, you never had a bench warrant on this one.
Me?
You never had a bench warrant on this one.
Is this the one where I had the crack pipe, the paraphernalia, and I got caught stealing from Myers?
No, this is the one where you were stealing from the store. Allegedly.
Right, from Myers, right?
Yep.
From Myers or Home Depot. Okay, that's what I thought.
Yeah.
And that's the one that you ruled on for.
No, this is Myers. This is Meyer.
That's what I know.
You were stealing stuff.
That's the one that
allegedly. This has nothing to do with the crack pipe. That might have happened before or after. It has nothing to do with that.
This right here is one of the most important courtroom moments in the entire hearing, because Judge Simpson is trying desperately to separate unrelated 5 allegations before the defendant digs herself into a deeper hole, and you can actually hear the danger building in real time. Miss Mason keeps connecting different incidents together because in her mind, they happened around the same period of her life. But legally, that is not how the court system works. The judge is laser focused on one specific alleged retail theft case, while she keeps volunteering extra information about crack pipes, warrants, and prior situations that were not even being discussed at that moment. That is incredibly risky. A lot of people think honesty means saying everything all at once. But in court, uncontrolled talking can create major problems. Judges, prosecutors, and defense attorneys all understand that defendants sometimes accidentally introduce harmful information without realizing it. And you can hear the defense attorney trying to stop the bleeding before things get worse. What makes Judge Simpson interesting here is that he's actually trying to help maintain boundaries. He repeatedly redirects the conversation back to the correct case because once statements start drifting into unrelated criminal territory, things become messy very fast.
It happened at the same time, Judge Simpson. It happened at the
I don't
same
know
time.
that.
You gave me 180-day rule, and you gave me a
Miss Mason,
$80.
Miss Mason, anything you say can be used against you. So would you please stop until we can try to get this matter resolved and we can deal with all that stuff at a different time?
Okay. So I don't want to go to no trial. What's going to take place now?
Okay. I was just going to adjourn it out so that everybody could talk to each other about it and get it. So I'm adjourning it to July 6th.
Thank you, Judge Simpson. Thank you, sir.
Thank you, Defendant Mason. All right, you have a great day.
Thank you, Judge.
Thank you, Your Honor.
There it was. Whole day just flying right along. And it happened. Okay. I'm afraid to call anymore. This is all Feaster.
So what happened, Judge?
Miss Kleeman, are you there?
I am.
Miss Kleeman, we don't have days like this.
I know.
I don't know what happened.
I don't know what's going on today.
Feaster,
Sorry.
no, it had to be you. This doesn't happen to Kleeman. All of what happened in the last 20 minutes would not have occurred.
Are you sure you want me to come back on July 13th?
I'll have to make a decision after some deliberation later because I don't know.
I don't know.
All right, let's try this one.
That little exchange we just witnessed says everything about how unusual this courtroom session became. Judge Simpson is practically joking with the attorneys at this point because the previous hearing completely derailed the normal flow of court. 5. And when judges start openly commenting on how bizarre the last 20 minutes were, you know the docket has gone off script. What makes this moment entertaining is the courtroom chemistry. You can tell these attorneys and Judge Simpson have likely worked together many times before, which allows for these small moments of humor and sarcasm in between serious legal matters. But underneath the jokes is something important. Judges value efficiency and predictability. When hearings become chaotic, delayed, emotional, 5, or repetitive, it affects the entire courtroom schedule. And now comes a major tonal shift. Because the next case is about to move from confusion and courtroom comedy into something much darker and far more serious. The energy changes immediately once the prosecution begins discussing a violent stabbing allegation involving a pregnant victim. Suddenly, bond amounts, public safety concerns, and community danger become central issues.
Jessica Blanche, appearing on behalf of people.
And good morning, Your Honor. Christina Costantino, appearing with and on behalf of Ms. Sierra Robinson. Ms. Robinson, can you unmute and state your name for the record?
Sierra Robinson.
All right, what are we doing?
Your Honor, this is a date and time set for probable cause conference. At this time, we are requesting that this matter be scheduled for an in-person preliminary exam at the soonest available date, and I would like to address my client's bond.
Preliminary examination in this matter will be set for May 2nd, 2023, 9 a.m., and that is before Judge Perry.
Thank you, Judge. Might I address my client's bond?
You may.
Your Honor, my client's bond is currently set at $2 million with no 10% provision. We are asking for a reduction of that bond. My client's 25 years old. It's my understanding she does not have any criminal history of any kind. She's not presently on probation or parole or anything of that sort. She is pregnant currently. And it's my understanding that she's been having some health issues while in the Washtenaw County Jail related to her pregnancy. We have some concerns that she may not be able to get the appropriate treatment for both her health and her unborn child's health. She does have employment lined up. Should she be released, she would have employment lined up at Kroger. She would be residing in Ypsilanti with her mother. I've personally spoken with her mother and confirmed that. Her mother is on dialysis, and Ms. Robinson typically helps take care of her mother tremendously. So she has some family obligations that a lower bond could help her to accommodate as well. She does have a high school diploma, and she does intend to enroll in college sometime in the near future should she be released. It's my understanding, Your Honor, that this warrant was authorized sometime in February. At the time, my client's address was not the same address that was on file with the felony complaint.
Listen carefully to what the defense attorney is doing here, because this is a classic bond reduction strategy. She is building a complete human profile for the defendant piece by piece: employment opportunities, family support, medical concerns, 5 education goals, caretaking responsibilities, stable housing. Every single detail is being presented to convince Judge Simpson that this defendant is more than just the allegations listed on paper. And to be fair, Bond hearings are often emotional balancing acts. The defense wants the judge to see potential rehabilitation and community ties. The prosecution wants the judge focused on danger and accountability. Both sides are essentially fighting over narrative framing before trial even begins. But then comes the problem: the size of the original bond. $2 million is not a normal low-level bond number. That instantly signals the court views these allegations as extremely serious. So while the defense is presenting sympathetic factors like pregnancy and family obligations, the prosecution is preparing to argue public safety concerns that completely outweigh them.
My clients indicated she never received notice that there was any sort of warrant. And she did come in custody. That was the first time that she learned about the warrant. It's also my understanding there'd be no issue with any sort of no contact order. My client does not have any need to see the complainant in this case. So we would ask the court to consider a bond reduction from the $2 million bond. My client doesn't have any financial means to post even close to a $2 million bond. But we would ask the court to consider a $10,000 bond. And I know that's a significant reduction.
All right, I'll hear from the people, but my understanding is factually, Ms. Robinson's accused of stabbing an individual who was pregnant, and then that individual had to be induced into labor. That's go ahead.
Those are the allegations, Judge. This was a random stabbing at a bus stop. So I have huge concerns for the community. While I sympathize with the fact that the defendant is pregnant herself, she did stab the victim multiple times, and in fact said that when the victim said, "I'm pregnant," she said, "I don't give a fuck. That's why I stabbed your bitch ass." And she was induced and almost bled out on the street. So I would not be okay with any reduction in bond in this case, Your Honor. I believe she's a threat to the community.
And Judge, if I might respond.
Yes.
Your Honor, first and foremost, we dispute those allegations, of course. I'd also indicate the discovery reveals that the complainant did not ever see a knife or any other device which was used to allegedly stab her. And for what it's worth, my client was also injured as a result of this and suffered a miscarriage shortly after the encounter with the complainant. But we dispute that there was ever any sort of stabbing, which is supported by the complainant's own statements to police that she did not ever see any sort of weapon that my client allegedly had.
She didn't see it, or the person that stabbed her didn't have it? I mean, there are differences.
It's my understanding from the discovery that the complainant said she believed she was stabbed, but never saw any weapon, could not describe the mechanism by which she was stabbed.
Okay, that's what I thought. Okay. Motion for bond reduction denied. Bond will continue as set.
And there it is, the final collision point of this hearing. The defense is aggressively disputing the prosecution's version of events. My five arguing that the complainant never actually saw a weapon and could not explain exactly how the alleged stabbing occurred. Meanwhile, the prosecution is framing the defendant as an immediate danger to the public based on the severity of the accusations and the injuries described. Judge Simpson ultimately sides with caution. The motion for bond reduction gets denied, meaning the original bond conditions stay in place. And honestly, once the prosecution described allegations involving a pregnant victim allegedly being stabbed multiple times at a bus stop, the odds of a significant bond reduction became extremely slim. Courts tend to move very carefully when allegations involve violent public attacks and potential threats to community safety. But this hearing also showed something deeper about courtroom reality. Bond hearings are not clean television drama. They are messy, emotional, procedural, and often uncomfortable. One moment you have virtual courtroom chaos and accidental insults. The next moment you are listening to arguments involving pregnancy, violence, miscarriages, and public safety concerns. That emotional whiplash is exactly why courtroom breakdown channels keep audiences locked in. Judge Simpson spent this entire session trying to maintain structure while navigating confusion, interruptions, emotional defendants, and extremely serious allegations. And whether people agree with the ruling or not, the hearing showed exactly how quickly courtroom dynamics can shift from humorous to life-altering. If you found this case as shocking as we did, Make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.